Hello and welcome everyone to the IAPP web conference, Data Brokers Unveiled, How to Vet and Choose Wisely, sponsored today by Lusha. My name is Selena, Programming and Speaker Coordinator of Sponsored Content here at the IAPP, and I'll be your host for today's program. We'll be getting started shortly, but before we do, a few quick details. Participating in today's webcon will automatically provide all IAPP certified privacy professionals who are the named registrants with 1 CPE credit. A recording of this program and a copy of the slides will be made available in your account under the My Purchases and My Recordings tab within 48 hours. Feel free to post any questions you have today for the panelists in the Q&A area located at the bottom of your screen. And we are looking forward to today's conversation. I will now hand it over to Assaf to kick off the program.
Yeah, thank you, Selena. So today we have here Odaya Kagan from Fox and Rothschild. Hi, Odaya, what's up?
Hi, nice to be here.
And we have also Callum next to me from Latham & Watkins. What's up, Callum?
Good to be here, Assaf.
Yeah. So actually, the reason I wanted to conduct this web conference is to assist companies to do prospecting in a compliant way. As the head of legal and compliance of Lusha, which is a data broker, of course, we get a lot of questions from potential clients, from my colleagues that are going to engage my competitors about how what they should do, how to vet, how to engage with a data broker in order to do prospecting proper prospecting. So first of all, just to curve out what we are not going to talk about. We're going to talk about data brokers, and data brokers are companies that actually get their personal information from third parties and not from the data subjects themselves. And we're going to talk about only the use cases of conducting B2B cases, which means when you're contacting other company or a persona in another company in order to sell something between the company. We're not going to talk about B2C, okay? And we're going to talk about two use cases, and this is very critical to understand before we start. How does the industry work? So usually when you're a customer, you in the old time you go to a data broker, and the data broker provide you with lists, okay, list of leads of people that you think ideal prospect, and you go and buy them. Today, most of the data brokers actually operate in a different way. You either can do the old school way, or you can actually upload your own customer data from your CRM or list that you purchase from a different place, and they can update or enrich it with phone numbers, emails, or whatever. So we're going to talk about the contribution of data to the data broker, and the data broker actually process it and give it to you back. And without further ado, we can start. So we're going to talk about on recently trends. We're going to go through US, EU, and I'm going to talk about the data broker industry. But the main course of event is belong to Callum and Odaya here. So Callum, would you like to start, or Odaya? Callum starts.
Go ahead and go ahead. So in the EU, the key laws governing the data brokerage is the GDPR, as you'd expect, and the e-privacy directive. We've seen quite a bit of attention on data brokers and the use of personal data for commercial prospecting in Europe. The key message from regulators is this is a lawful practice, but it does require some sort of critical steps and critical diligence of how you're going to use the data and what your data broker has done. It's been a key area of focus from the UK ICO, as well as from the French regulator, the CNIL, who looked at commercial prospecting as a priority topic in 2022. And we've seen some recent enforcement and decisions around the use of data brokers, primarily in a B2C space, which isn't the topic here, but it really helps to go back to the first principles. And regulators have been focusing on key issues like notice, telling people what you're doing with the data, making sure that you know that their data has been used and collected by a broker, having a lawful basis, making sure you have one, that you identify it, that you know what it is, that you tell people what it is, so very first principles, and diligencing the broker. to making sure that they have proper data protection processes in place. We do expect there to be some sort of more attention here. It's a tricky area, but we have some sort of guidance we'll talk about as well. Adia, is that sort of similar to what you're seeing in the US?
Yeah, so a little bit of like level setting here. First of all, I wanted to make a comment on the B2B, right? Because everybody's saying like B2B immediately is like, oh, so we're carved out of all of the laws, right? No. One, California famously no longer has a B2B carve out for general applicability of the law. And the other is notably, which I will note in the sort of US ecosystem, is the Federal Trade Commission. The Federal Trade Commission is very active in enforcing privacy generally, but in this space specifically. And the Federal Trade Commission does not carve out B2B. And in fact, this whole started, right? I'm going to do the Putin in like 1958. The Federal Trade Commission issued a paper. No, in 2012 they started this study of data brokers, and which led to a paper from 2014, which kind of sets the scene for what the FTC is thinking and has now recently been implemented. And the study included 9 data brokers, 4 of which were B2B. So first of all, B2B is in scope. Generally, obviously, the ramifications are different, but it's not like out of scope, right? So in the US, the other thing to kind of think about is the information publicly available? That's one big difference from the EU. EU publicly available is personal data. And then you're like, okay, well, how do we address it specifically? In the US, there is a threshold decision to make. Is the information really publicly available or not? Won't go into detail here, but it's important. Not just because it's publicly available doesn't mean that it's publicly available. That is not a typo. That is how the legislators wrote that law. So just because you see it doesn't mean it's public. And also it matters what you do with it. So if you do something with something that started out publicly available, but you've enriched it, etc., changes things. So that's very important. What's going on in the US? So the US has a couple of different things related to data brokers. Number one, there is a registry requirement. There are a number of state laws that require registration. And the other is addressing the processing itself, which we also call processing, of what is going on with the data, right? Like, what are you getting? What are you giving? And so we're going to talk about that a little bit more. So we have these laws. It got an honorary mention in the APRA, which is the federal bill that we have, federal privacy bill, that also addresses the same issue. And we have the FTC, Federal Trade Commission, and the CFPB, which is the entity in the US that deals with consumer finance, both having a strong spotlight, let's call it, on data brokers and the dealing with data brokers, because there is a very strong emphasis among US regulators, generally California and others, on data sharing for a commercial purpose. And so that, data brokers are one component of that. Oh, you're on mute, Assaf.
Yeah, thank you. Nice to hear that other than election, there are other stuff happening in the US. So recently, since the rise of AI, and we all know that all the data is out there already, it's a crowded market, and we get a lot of questions, how do I vet a data broker? So we put together some kind of a list. We're going to go through it about what kind of due diligence before you engage. Later, we're going to talk about how you engage, and then we'll talk about what you do after you engage. So let's see
Make money, hopefully, no?
Yeah.
Or you can't say that in privacy webinars, but in the US, we do have that. In the EU, maybe it's not an issue, but in the US, the end goal is to do business at some point.
So
I mean,
if I'm a US company, what the regulator asks me to do if I need to engage with a data broker? What kind of due diligence do I need to do?
Yeah, so the first thing is, what's interesting is, and I won't steal Callum's thunder too much, but it's the FTC, right, is looking, the concept of I sort of always think of like, you know, don't look a gift horse in the mouth, but do look a data horse in the mouth, right? So that, and this was not a traditional US approach. So in the past, right, under CCPA, for example, the approach was, you know, you can. Now the question is just what type of pieces of paper can you stick around it? CCPA changed that. We don't have a proper dictionary of legal bases, right? But you do need to fall into this concept of European sort of concept of fair and lawful, right? Like you need it. It's not by definition that you can do this. And the FTC, the provenance of the data, right? Is the data that you're acquiring, was it properly gotten to begin with, is something that CCPA wanted to do. At one point, there was a version of the regs that said, you can't just get, you know, something from a data broker, you need to get like reps and you need to go look at their consents. Then it got deleted. So the states do this, are less concerned with it, even though if the data was ill-gotten, you can have liability issues with it. And also it affects where it came from, affects where it's going. And so we'll talk about that. But under the FTC jurisdiction, right, where is the data coming from? And did the source have permission to get it, is important in the US as well. So those are questions you need to ask. Publicly available. Yeah.
People want to know if a data broker tells them they scrape the data from the social web, is it okay or not?
So I hate to be the lawyer here, even though everybody's a lawyer, and say it depends, right?
Okay.
So the scraping depends, and in very, very abbreviated format, right? The question is whether or not it's not enough that you say I scraped it from social media. It depends on whether it was legal. Was it behind a login? There is case law that says that this is a breach. There's a bunch of case law, right? Was it in breach of technical things that you circumvented, right? Like robots, TXT, we talk about like in the AI. Is there an applicable terms of service that you were bound to and breached, right? There is case law. There was just a case yesterday about the Computer Fraud and Abuse Act, CFAA, right? So if it is the fact that just like I said before, the fact that it is available to the public does not mean that it is publicly available and therefore open season.
Yeah.
Should I stop here and let Callum do this?
I think we're seeing the same approach in the EU, right? So we have like very clear guidance that just because something is publicly available, it's still personal data. Just because you make it publicly available, it isn't consent to use the data under GDPR. You need to go through and you need to examine whether you have a lawful basis. But at the same time, fair and lawfulness really are big considerations for European regulators. And we have some helpful guidance that says, you know, if the data is available on a public-facing company website, and if the data is a first name, a last name, a job title, really sort of very basic B2B data, which is often what we're talking about in the B2B marketing context, where we're trying to sort of get some leads, reach out to sort of people in charge of procurement or sales. Then sort of expectations of fairness, the expectations of the data subject, that's different from a B2C ad tech sensitive data context. It's very straightforward. So the concept of fairness, which is elastic, might be more in your favor if it's already sort of out there. It's sort of one to weigh in. We've seen some guidance as well on scraping. And I mean, as Assaf was saying, that sort of comes a lot with AI and training data. And we've seen quite a lot, especially probably alarmingly, something from the Dutch regulator, which had sort of guidance titled "Scraping is almost always illegal," which kind of sets out a clear view, but it's quite nuanced. I think we have to look under the hood of the title and see what it's actually saying. And here they sort of talk about, really in a B2C context, so it's a different risk entirely, but they talk about legal basis, consent being theoretically possible, but in practice it can be somewhat difficult, just reminding you that if your data is publicly available, publicity isn't consent. So that's really what we'd expect. Personal data is still personal data, but then it sort of says, if consent isn't available, we look to legitimate interest. Now, the Dutch regulator is very unusual in the EU. because it takes quite a controversial and strict position about commercial interest not being a legitimate interest. And that's really why the lawful basis guidance came here. And that approach is currently before the Court of Justice. So we expect to have a ruling on that at some time as well. And it is a bit out of sync with what a lot of other regulators are saying. And then we go into what is legitimate interest. So we all know that we have to take a balancing test and review it. And the Dutch guidance itself does give some quite helpful factors if you want to rely on legitimate interest. So they look at the scope and nature of the processing. Again, we don't want a lot of data. It's not going to be data about vulnerable individuals, children. It's mostly going to be data about individuals who work at a company. So we're looking at a very limited scope, probably complying with data minimization principles, just basic contact information here. Then the Dutch regulator says to look at the expectations of the data subject. Again, all linked to fairness, but if your website has your phone number or your email address publicly available, you would have maybe a reduced expectation that that data would be private, and maybe you would expect that individuals would reach out to you about opportunities, and then sort of consequences for the data subject. That's what a lot of the Dutch guidance focused on. And here, this isn't about profiling individuals. Really, what we're talking about is receiving communications to sort of commercial communications for marketing. So it's quite, I think while the headline of that advice might have been sort of quite alarming or scary, if you dig into it, I think there are quite unique factors that would help assess fairness and lawfulness of B2B processing and engaging a data broker. So ultimately it is sort of a risk-based call, but it's important to sort of think through these and document these and actually look at what the risk is and look at the context of getting the data, as you say.
Yeah, indeed, and I see there are also a related question here in the Q&A about commercial interest. So we believe, like the data broker industry, I believe that I speak only on behalf of my company, but what happened in the industry is that once we have people put out their business persona out there in a LinkedIn or in the website of the company, they have some kind of expectation to be addressed on a business matter, and this is the commercial interest. You're not going to approach them on something that is not that way, only in relating to their business, and this expectation eventually get higher expectation when they get notified. So let's talk about the notice requirements.
Yeah, and just on that briefly, sorry, yeah, commercial interest would normally be a legitimate interest that would go through the three-stage balancing test in the Q&A. I think the Dutch regulator has a specific view on that, which is sort of a bit out of kilter and being challenged. So again, we can go on to another idea today.
So this thing of the reasonable expectation of the individual is the focus for the FTC. It's also a focus in when you are looking at, you know, the level of transparency required and analyzing when the FTC, that's the analysis that they're doing, because the FTC, right, the mandate of the FTC for enforcing in the absence of a law, which, you know, you guys are seeing that the US may have one or two things to do before January, so probably not going to be a privacy law, but right now the FTC is operating under the FTC Act, which addresses unfair or deceptive acts or practices. And when talking about unfair or deceptive, they're talking about reasonable expectation. The issue that has been raised both in the EU and the US about data brokers is that it's so-called invisible processing, right? Like you don't know that it's happening. But if the thing that you don't know is happening happens to be the exact thing for which you put your data out there, and what you are wanting to happen with your data, those are aligned, right? And so then you may have a reasonable expectation, right? And so it is in the US, both under CCPA and the data broker registration laws, you have a transparency requirement. You have a separate transparency requirement when you use the information, but the data broker also has a transparency requirement that you're sort of relying on. But the bottom line is that the person needs to understand what data is being processed and what is happening with it. And in the US, also very importantly, where is the data going, right? Is it being shared in a commercial way, right? In sort of I think probably B2B is really not, it's not really relevant, but there's another, if there is sensitive data involved, then, profiling or sensitive inferences are a thing that are important, because the FTC is concerned with those types of impacts that could be happening. But the unrelated is sort of the commercial aspect of it. Like, is the data being shared, and is revenue being made off of it?
I think that's something that we kind of commonly would advise anyone when they are going to a data broker, is just to ask and really diligence that the data broker has notified individuals and has allowed for sort of opt-out and rights. We'll discuss that on the next slide. But if you're selling contact data, or if your business is making that available, you can't rely on any exemptions like impossibility, disproportionate effort. I mean, the whole idea is that you can facilitate a communication with the individual, so you should be able to send them a notice quite easily. So normally when we're diligencing the data brokers, we'd ask to see copies of the record of the notice, confirm when it's sent out. Is it sent out within 30 days after receiving the data under EU law? How do you deal with notices? Is it email only? What do you do if you only have a phone number? A lot of our clients might want to call individuals on a business phone number. So do you send SMS notices? What a common way of doing it. And a lot of people don't do this. You have to really assess that and understand that as part of your diligence. And then, does the notice contain the right provisions? Is it really clear what's going to happen as a DSS? That's so critical. That goes to the expectation of the data subject. And is there a clear right to sort of opt out or delete your data? So those are sort of common things we would really look at in diligence. And notice is a big point. It's a cornerstone of compliance in GDPR and US law as well.
Yeah, I can share with the crowd here that it's only few, really few. I think I can count them on one hand. Are the numbers of data brokers that actually notify the individuals in the EU or California as I believe proper they should, and it's very important when you retain a data broker to make sure that they do it properly, because it implicates you. Let's move on, because we are short on time.
The important thing to say, and we talked about this earlier, so we can mention it here, right? I will give you an IKEA metaphor, right? Like, it's always on you, the company anyway, right? Like, what you do with the data, how you contact the people, what you're doing going forward, that's on you. It's also on it's also in both. It's on the data broker, right? So the data broker is responsible in your IKEA package that nothing's damaged and all the legs are there, right? But they're not responsible for you putting it together in a faulty way. So you need to make sure that both of those, right, are buttoned up. And so it's on the data broker to do that. And it's required by the FTC and required by law in the US, and it's also on you.
Yeah, indeed. So we talk about the notice that has to be delivered, especially in the EU. What kind of in the notice itself? I know that we need to provide, the data broker needs to provide special data subject rights regarding right of erasure, procedures. Callum, can you enlighten us?
Yeah, I mean, I think the key thing for the notice as well is just making sure that individuals can opt out for two reasons. For the reason of sort of that's required under law. You need to have that sort of ability to delete or suppress the data. You need to make sure the data that's deleted isn't re-added. But also just for you, if an individual doesn't want to be contacted, doesn't want to be on the list, it's unlikely they're going to be a successful sort of sales prospect. So we want to make sure that those procedures are in place. So the list you're buying is actually sort of a higher value list. And is people who are aware this is happening are less likely to sort of have issue with it because they haven't opted out, and are more likely to be receptive to receiving the sales or marketing. The other thing that's worth noting, sorry, is just if someone opts out later. So under Article 19 of the GDPR, if you make a deletion request and you pass the data on to other controllers, you're obligated to notify the recipients of the data. And again, that just means that it's not a one-time opt-out. It means that if individuals do ask for data to be deleted over the course of your engagement, you'll get that information. And again, that that just helps keep the value of the list high and the data sort of accurate and relevant for you.
Yeah, I want to give a good tip to the people that are going to purchase data from data brokers. Because there is an amount, don't buy a big bulk of data. Buy it in a small portion, because when you buy in a big portion, if there was data subject request to be removed, then data broker will tell you have to remove it, and you didn't have time to approach him and to maintain different legal basis to continue to engage with this prospect. Okay. By the way, when there is Article 19, we as a data broker, we are forced to notify the companies that purchase the data, but the companies are not obliged to delete it, because if they have different legal bases, maybe they already contact them, maybe they are already the customers. Maybe we sold only enrichment and they already been in their database previously.
It's the same thing in the US, basically, right? So in the US, you have to honor its personal information or personal data, depending on the law you're under. You have to honor the rights. Key among them is, despite the name of the opt-out, right? And there is this Delete Act, which is in California, which is already in effect, but now there's a notice of proposed rulemaking with respect to some things that are unclear, that requires requires California to have a centralized, like one, I don't want to say one-stop shop, because now all the Europeans are like, well, that's not going to go. But like a one-stop shop for deleting like data broker data in order for this to be more facilitated. A couple of things that I want to add, because otherwise it's pretty much the same, right? In the US laws, you need to do it, delete it, you need to notify the downstream, like all of that stuff. A couple of interesting things. One is, which is a new revision to the CCPA under the new regs, is that if you get a right to, this is on the customer side, on things to do on the customer side, not necessarily on the data broker side. If the interaction between your right to delete and data broker data that you get. So if you get a right to delete or a right to rectification, right, which is the accuracy piece we talked about up, in the previous slide, you need to have procedures that make sure that when you have a right to delete and then it gets overwritten by information that you get from a data broker, you're still honoring the right to delete. Or if you have a right to rectify, you have, Callum's last name is now being spelled with a GH, and he's very offended, and he made a request to fix this in honor of his heritage. And then you got some data broker data, and now it's GH again, right? That's a violation under CCPA. And there's also something interesting, which I don't want to like specify, I don't want to take too much time, but I didn't do my plugs. I'm going to use that. Anybody who's interested, I will post a summary of the session later. So feel free to connect with me on LinkedIn. So I'll give some more detail. I won't take up Callum's, time, but there is a specific provision in the US laws that talks about the deletion of data that you did not directly collect from the individual. And it's sort of like I'm going to call it like a soft delete. So that's also an interesting quirk in the US laws. Yeah,
I think we are 5 minutes behind time, but we will do it very fast. So, and another issue that we get a lot, do we as a data broker, do we scrap the information against do not call list? There are certain do not call lists that we do it, and the data brokers do it. And some of them, people are not aware that do not call lists are usually in most of the world are mainly for B2C, and usually B2B is exempted. What's happening in the EU, Callum?
Yeah, it depends on the member state, as you probably have guessed. But for example, in the UK, we have the corporate telephone preference service. So before you use the data, you need to screen against that for sort of commercial enterprises reaching out. And I think that the important thing is you just need to know. You just need to know what's been done to the data, what hasn't been done yet, so you can assess what you need to do to comply for your sort of further use of the data. And that's the key question, really, is like just understanding what's happened, where it's from, what's been scrubbed or not yet. And you should expect your data broker to be able to answer these questions very transparently, very quickly, so you can assess your own compliance step.
Yeah,
Yeah,
I recommend to ask your data broker if they are an official cleaner of the TPS, CTPS. It's very important that they will not use a third-party vendor to use it, and they will have the full liability as an official cleaner. Yes,
Yeah, and just one sentence here for the US is I'm going to say someone needs to do it, right? So this needs to be done. It needs to be scrubbed. It needs to be vetted. If it is a robocall or an automated text message, you have a whole other regime like TCPA with literally $500 a pop for violations. So somebody needs to do it. And so the first thing is ask the question. And then, because we've done this with some data brokers, and it's like, we got some vague rep on client shall ensure that, like, and then you decide, right? Is this like, can I do it? Am I equipped to do it? Do I want to do it? Is it, am I paying for it? Like what? But somebody needs to do it basically. And you will get the cost of the violation will be yours, right? So like if it wasn't done, it's like with my kids, right? Like someone needs to unload the dishwasher. I don't really care who it is, but if the dishwasher is not unloaded, there will be a problem.
I love your examples. Well, I like it. I think that's a good sense. If you deal with data broker, you need to make sure that they know what they're doing. And in order to know if data broker is not just two students with a laptop selling off data off the web and telling you, yes, we are compliant, yes. You need to do some kind of a DD. And for me, I think there are a lot of US requirements and EU requirements to make sure that if they follow these governments, there is some kind of presumable assumption that they will follow other legal procedures. Odaya?
Yeah, no, I agree. That's what I think. I think that I think the diligence is important, and I think you get a sense for it, right? Like I've had colleagues, and I used to do M&A too, and I have colleagues like, oh, they gave us a flat rep. I'm like yesterday they had no idea what we were talking about, and today they give you a flat rep. So do you think that this is actually happening or what? So there's also the balance of like you know you have a piece of paper, but if you get a sense that this isn't actually happening, when there is an issue, the issue is going to be on you. It may not be on you legally because maybe you will have recourse, but if it's two people in a laptop, you're not going to have recourse because there's nothing there. But also it's your reputation, right? It's your people, it's your contacts, it's your company, and so you will be left with the problem.
Yeah. And I think for privacy professionals, you know, we have a lot of pressure from sales teams to do it, but it really, the question is like, is the data accurate? Have they thought about this? Have they given notice? Because ultimately the leads that your teams are going to use are going to be a lot more valuable when you do engage. Another thing we've seen are sort of looking for auditors around data privacy, data security as well. So that can help get under the hood a bit more of compliance generally.
Okay. Good. So I think when I vet my vendors, not necessarily data brokers, I usually ask them, do you have any kind of open litigation? Are you have all the certification and licenses in the states that you need to operate? And I'm not only, when I deal with data brokers, I usually check if they are registered. When they tell me, yes, we do, I also check if they are registered. Okay, I double check. It's very easy to enter into the registry of California or Vermont or whatever and do the check. If they are not there, it's a big red flag not to do business with them. Okay, also another issue with governance. For example, I know that some data brokers do not have legal in-house, no DPO, no whatsoever. So make sure that they have a DPO in place that can give you the assurance, and he or she will giving you the answers that you need.
And in the US, right, the issue is if the data, you can be liable, right, for your downstream, right, and upstream, right? And so again, this is like the quality of the diligence you want to do as much as you can. And the FTC and the FTC has said this in recent enforcement actions. There was X mode and in market. Basically, they said there was an issue with respect to SDKs or with respect to consent. And unlike the sort of traditional US approach, the FTC said that one of them had some reps from the broker that said, or I don't know, they were the broker, but anyway, they got the data from somebody. And there was a rep that said, we comply with all applicable laws. And the FTC was like, that's not enough. You need to actually ensure that the consent was gotten, and you need to check it. And if you find out that it's not, then you need to have provisions and leave, right? So this, the concept of, again, right, when I used to do M&A, my colleague said, well, why do we need some privacy provision? Can't we just say comply with applicable law? No, you can't, right? Because it doesn't work that way. And so in this situation, the FTC at least is saying it's not enough to say, to get like some sort of, we comply with all, we materially comply with all. No, you need to actually go in and look.
Yeah, and that's just to echo, that's exactly the same here. I mean, we've seen enforcement on this in the B2C space, and while the risk is different, the principles are the same. They would expect you to actually look under the hood and actually do this diligence, especially around notice and rights. These are sort of key areas of consideration. So
I'm saying that you will be surprised that a lot of data brokers, or maybe you will not be surprised, a lot of data brokers are currently within litigation, are currently under review. Some of them are even in claims for wiretapping. You don't want, if you will not ask, you will not know.
And I'm going to say the opposite, because in the US, Mike, with a question that I always get, but why is so-and-so and so-and-so doing it? And the answer is basically because the class action lawsuits and the FTC haven't gotten there yet. The fact that, somebody is under litigation obviously is a red flag. That somebody is not under litigation is not enough of a white flag, right? You need to be somewhere in the middle.
Yeah. Okay, after the courtship, after you do due diligence and they answer questionnaires and they tell you, no, we are okay, no, we are compliant. Eventually, you need it on paper, okay? What we advise, and we see a lot of data brokers writing, they write on the website, we are GDPR compliant, we have everything that you need. But when you confront them and tell them you have to write it in the contract, they disappear. So you want, in order to protect yourself, you need to take representation regarding the collection and the right to sell the personal information. Okay, it's very important to be written in the contract. It's and to get and to be compliant, it's a lot of data brokers we see. They write whatever you want. As you say, they give you flat representation, whatever they want. I recommend that you get assurances from third parties. Today, we have enough auditors around the world that do impartial third-party audit, and they check that you're GDPR compliant, CCPA compliant. And we get these kind of questions a lot, and what we do it annually, by the way, in Lusha. And we start to get it from all kinds of jurisdictions. So, and of course, legislation is changing everywhere all the time. So after the GDPR and CCPA, we cannot do annual report audit in every jurisdiction there is. So what we did, we went and do the ISO 27701. Okay, this is the new privacy international standard. It's based on GDPR. So it actually combines all of the privacy laws worldwide, and usually takes the strict approach. And it's very, I think that data brokers that has this kind of certification that is accredited, okay, you have to be, you have to understand that there is regular certification and accredited. Accredited is being vouched by an international body, and another party, not third party, but another party that will vouch the audit. I think it's a very good practice to ask your data broker to get this ISO, just like you ask for SOC 2 or ISO 27001. I think tomorrow is the next standard, okay? You want to add something, Carlo, Modea, about it?
No, +1.
Okay. We talked about privacy notices. You need it also in the contract. They will give you representation and warrants. that they do it, and they give you the opt-out, what we talked about. And another issue that is not related so much to privacy, but we see this as a bad practice in the industry, and I want to warn customers out there. We sometimes encountered a post-usage clause that doesn't allow the customers to use the data after the agreement is over. And for that to bound the customers to
This data will self-destruct within 30
yes,
seconds.
exactly, something like that. And sometimes they say that they are the IP owner. I don't know how you can be IP owner of a phone number that is not it doesn't belong to you, but you should read the fine print as well. And last but not least, and very, very critical to this conversation, is about the role of the parties. Usually to the agreement there is a DPA, and we need to talk about the role of the parties. Just to bring you again to this matter, usually you either buy data purchased. So as you know, the data broker usually is in control. The data broker collected the information, is responsible with whom he shares the information, and with whom he's sharing it, and say to the customer. And on the other way, when a customer provide information to the data broker, usually I see it as a wrong interpretation. The customer and the data broker are not controller and processor. It's a controller. The data that is being given to the data broker to enrich. It's the customer data, and the data broker should act as a processor. Okay, Carlo, did I get it right?
Yeah, that's right. You want to just be very careful about what they are doing with your own data. So reading those terms very carefully, making sure there are only sort of limited options for what you're doing. Really, it's a question of accountability, about control. So you want to have that relationship in place, and that's what we would commonly advise.
So in the US, this is actually very, very like a very hot topic, right? I said the data sharing is the key issue here. So a couple of things. First of all, in the data use post-termination or data use generally, right? So the roles of the parties are kind of driven by like where's which data is going in which direction and what do they get to do with it. Now, this isn't a like go or no go, right? Like it's not like prohibited or not. You can provide for it in an agreement. So the first thing that you need to do, and the FTC has now discussed this to the tune of like millions of dollars in enforcement actions, right? There have been different contexts, different data, but the same concept. There's enforcement actions from BetterHelp and GoodRx where there was inadvertent, and by inadvertent, they mean they didn't know. It wasn't inadvertent. It was the company did not know that this was going on. And so just like those of you that are lawyers and remember, this is literally maybe the only useful thing I've ever learned in criminal law that I used, right? Since like first year of law school, which is right, the levels of mental state, right? So reckless is when you do something without the intention of achieving the result, still a problem, right? So in this situation, when there is data sharing that you are not aware of, right, that is a problem because you are, facilitating commercial sharing. As you know, the FTC and the regulators are very concerned with this. The data is getting monetized. The person doesn't know about it. This is the invisible person. There is no expectation, reasonable expectation, because if you don't know this is happening, of course, you can't tell anybody that this is happening because you didn't know. And so in that situation, there were BetterHelp, I think, was sharing with a number of very ubiquitous providers through third-party trackers. And BetterHelp told the FTC, well, we didn't know. It was buried in the agreement. It was buried in the standard terms of use. Nobody alerted to us. And the FTC was polite, but it was like, dude, like, are you 3 years old? Like, can you like read the contracts that you enter into? There was a different context where something was happening and data was inadvertently shared. And the company's response was, we put a junior marketing analyst on it. And the FTC was, well, don't put a junior marketing analyst on it, read it. So the first thing on the data use, right? If you are not reading your contract, and you missed section 49 of whatever that says that they can do it, that's on you, because you're a B2B, right? In the B2C context, when you're giving the notice, you cannot bury it in, like linked document number 14. That's your problem. But in this situation, right, you're a business. Read everything that you enter into, even if it's buried somewhere else, number one. Number two, with respect to roles, if there is sharing and the nature of the use by the broker makes the broker a controller, that sharing by you can be a sale under the US laws. If it is a sale and you didn't realize this and you didn't give an opt-out, you have a problem, number one. And if you have in the US, this hasn't been enforced, but under the US language of CCPA, right? Unlike with GDPR, where if you don't have an Article 28 agreement, the technical fault, you get some sort of fine. There've been a few small fines. In the US, if you do not have a DPA with the data with a service provider, they're not going to be a service provider. And now maybe you have a sale and maybe you didn't give an opt-out. So read the contracts and make sure you have the right provisions.
It's the same in the EU. You need to make sure that in the contract you are a controller, and independent one, not joint. You don't want to be liable for the data broker to be jointly liable. So you make sure that when a data broker is when you purchase data, you are a controller, independent controller, and when you provide data to the data broker, you cannot use it for anything else. I think we're going to jump. We got back to it later. So it's very important for you to put in a contract to prohibit data vendor to sell your own data. Okay, that's for sure. We established this. Okay, and it's not enough to have it in the contract. As we said, I think that you need to also get assurance to ask in the DD on a questionnaire. Do you have separation of databases? For example, in Lusha, we save out the contact database that we sell is in a different physical zone, okay, and the customer data in a different place. So not only that, usually we get also some kind of privacy by design assurance certificate, and you want to protect your data as well to make it secure. So this is regularly for every vendor you put your data in. You usually ask these security standards. Some of the clients ask EU localization. It's not necessarily, but if it's important for you, you can ask data broker to have localization. And of course, you don't want your data to be out there on the market to somebody to write on GPT, ChatGPT, what data does your company has, and then it will spill out. So make sure that you get also reps and warranties about AI training over your own data, that it will not be publicly available. I'm putting the last slide. 1 second.
So can I take 2 words about the last 2 things? First of all, AI, no, the last 2 bullets. So the AI thing, that's a like story for another webinar, right? As soon as you start mixing in AI, the whole legal regime in the US is different. The FTC is there. It's a bit like that. We put a pin in it. If you can invite us by popular demand, but this is a different story, right? The localization piece, the US traditionally didn't really care. The only thing, and it doesn't apply to this context with the sort of non-sensitive B2B data, but I'd be remiss to talk about a broker webinar with a US perspective without mentioning the new foreign adversaries law that was passed, which sort of got passed kind of in conjunction with the TikTok law, but it's not the same. It is a law that prohibits data brokers to sell or transfer or disclose sensitive data, like a lot of sensitive data, to a foreign adversary country or an entity controlled by it. 2 things. Foreign adversary is China, Russia, Iran, North Korea. If your data is being somehow shared in those stored, shared, whatever, in those jurisdictions, that's a red flag. I had that in agreement. I was reading some exhibit of an exhibit. It's like, ooh, Iran, why? Like, why? What's happening? So that is something that you need to make sure. And the other is not relevant for this particular discussion, but for your kind of data broker engagement. Sensitive information, it's not normal contact details, whatever, but it is more broad under that law than you may think. So that's something to keep in mind.
Okay, I want to skip back to the slide that we didn't do. 1 second. About we get a lot of questions about, okay, so I did the DD, I put everything in writing from the in respect of the processing and collecting. Now I get an assurance that I can use the data without any problem. Then we get back to your IKEA model that data broker is not in charge of what you do with the data, right? Because as we said, it's independent controllers. Once the data is transferred to the customer, the data broker cannot actually govern the way you use it, and you do need to follow marketing laws.
So
Yeah.
I gave my IKEA comment, and I'll give my M&A example, right? Like those of you that do M&A, right? The seller can give you all the reps about what they did with the stuff, with the data, with the whatever, up to the date of the closing. They can, and sometimes do, give you a rep that if you use the information in the exact same way that we have used it, that should not trigger laws. That's an annoying rep, but like I've seen those. The one that you can't give is the seller, and here the broker can't be responsible for what you do with the data after you buy it. If you use it, you are, first of all, you're in charge anyway. The buck stop was with you anyway. Even if the data broker is also liable, it's mainly you, because the data broker is not dealing. The data broker is, they're like surgeons. They don't deal with people. It's like the GP that's got to talk to them. So you're the one that got to deal with the people. It's your data, right? But if you use it differently, that's all on you.
Yeah, I think this just goes back to the key principle about even the contracts, even the cleansing, just making sure you are accountable, you know what's going on, and you're ultimately in charge. So you have to send your notices, you have to comply with direct marketing laws, whether those are, for example, and for the B2B context, you have to sort of look where you're going to do your marketing and figure out which apply. You have to do the screening, or you have to understand if it's been done. Like those are sort of the key elements. It's ultimately it's your compliance. So you need the data broker to help you understand what's been done, what needs to happen, so you can take steps to be responsible.
Yeah, indeed. Okay. I think we are in the last slide. Lusha is the sponsor of this IAPP web conference. We just want to make sure that when you buy data, you get the full assurance that you get. Lusha is GDPR compliant. Lusha is being audited annually by a German state certified auditor, also by Trust E in the US for validation for CCPA. The ISO certification is accredited, and we make sure that your data as a customer is protected, and we don't take any data that we need and more than we need, and we don't sell it. You get a warrant in the contract that it will not be sold, and of course, all the security standards, as you can see, is up to date. Having said that, without further ado, we can move on to the Q&A. Let's see some questions. For the territory of the EU, apart from GDPR, are there any other acts like the Data Act, the Data Governance, applicable to activities of data brokers? Callum, I guess it's yours.
Yeah, I think it's a good question. Obviously, the privacy directive and its implementation. For the upcoming ones, it's probably best just to reach out and we can have that chat individually. If you have any sort of specific concerns, we can go through it.
Okay. I got some questions here. Do we have a checklist? So I will make sure to compose a checklist, and the attendees will be able to download the checklist. By the way, Lusha has also a world map of marketing laws, so you don't need to go and run for each jurisdiction. You have everything in one place. You can find the world marketing in Google, world marketing map of Lusha, and you can find it and see all of the marketing laws in one place. It's not a legal advice, it's a resource for you to be helpful. Let's see the last question for today. Is consent obtained from a data broker transferable to another entity? So let's look in two perspectives. First of all, most of the data brokers do not gain consent. They gain the information from third party. They don't have direct relationship with the data subject. So the legal basis for them under the EU jurisdiction is legitimate interest. So there is no consent to be transferable. Regarding the notice, I know that there is some kind of interpretation of the law, and we don't know until there will be a ruling, that the notice of the data broker that actually write in the proper wording that say that notify the data subject about his usage of the data is being transferred to certain types of companies, and you fall within the company, it should cover you. As I said, it's not legal advice, it's some kind of interpretation today. There is no ruling about it, but you have to understand that sending emails of Article 14 is very hard to do these days. I don't think that any company can do it alone. Only data brokers have the efforts and the ability to send those kind of notices, especially in the today regime that no web server, email server wants to send a cold email to people that you had no relationship with. And the website that I said, I see another question, but the website that I say is Lusha, Lusha, World Map Marketing. You can find it there. Selena, I think we're a wrap, okay?
Yeah, that's great. And that's all the time we have for today. Thank you so much, Assaf, and thank you to Odia and Caleb for sharing these really valuable insights with us today. I also want to give a big thank you to Lusha for sponsoring today's webinar, so that's free for our audience. Lastly, I do want to encourage you to click the survey link that was dropped in the chat. Briefly give us your feedback on today's program. Will help us to improve our future webcons. We greatly appreciate that. And that wraps up the program here today. Thank you all again so much for joining us. We hope to see you in another IAPP web conference soon.
Thank you.